During closing arguments in your medical malpractice trial, the defense attorney gets up, turns to the jury during closing arguments, and says, "Ladies and gentlemen, Oginski failed. He failed to bring in a treating doctor." Why would he do that? How could he not bring this doctor in to testify? Is that appropriate for him to say? Likewise, could I turn around and do the same thing and argue that the defense lawyer has failed to bring in a specific doctor to testify on their behalf? You want to know the answer? Come join me on this walk around the neighborhood as I tell you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is yes and yes. Now, during the course of the lawsuit, if it turns out that one side or the other or both have failed to bring in a doctor whom each side or each attorney believes would have been helpful to the jury, now that attorney can argue during closing arguments, hey, listen guys, why didn't Oginski bring in this doctor? If he was so crucial, he was the one who treated the patient for the following problems. Don't you think it would have been helpful for you to understand what he observed and what he did and how he treated the patient? Wouldn't that have been useful to you in coming to a decision about whether or not this other doctor was careless? Maybe, maybe not. Now, there might be a great reason why a particular doctor was not called in to testify. Maybe his testimony would be cumulative, meaning that there are other doctors who already came in to talk about those particular issues. That's one reason. Maybe the doctor was not receptive to coming in voluntarily and we didn't want to go ahead and serve a subpoena on him. That could be another reason. He might be a hostile witness, meaning he's not going to give us any information that's favorable to us or voluntarily give us favorable information. Even if I subpoena a doctor to come in and testify, now, if the doctor is hostile, the most I can get him to do is talk about his treatment. What complaints did the patient make? What problems did she have? What did he do for her? And that's it. I can't ask him expert witness opinion questions. Why? Because he's not coming in as an expert witness. He's only coming in as a fact witness. So, I may have other witnesses who have already testified about that. My medical expert might have already testified about this doctor's care and treatment and talked about how he reviewed that, and now the jury has already heard about it. So it may not have been necessary to go ahead and bring this doctor in to testify. But now, why is the defense attorney trying to make a big deal about the fact that we did not call in a certain doctor? I'll tell you why. He wants to get the jury to assume that we're hiding something. He wants them to believe in their minds that the only reason we have not called this doctor in to testify is because we are hiding something. And if we really wanted to go ahead and reveal to the jury what this doctor knew, we certainly would have called him to testify. But you know, that's a double-edged sword, and that's a problem sometimes. Why? Because we can raise that same exact question. We can turn around and say, hey, listen, the defense attorney is accusing us of trying to hide something. But guess what? If this attorney really wanted to know what this doctor had to say, all he had to do was serve a piece of paper on this doctor known as a subpoena, which compels him to come to court. And now he would have been able to ask him questions of exactly the information he wanted to learn. And now you, the jury, would have known that information. But you know what? The reason why we didn't bring this doctor in is because of A, B, and C. So now the attorney's argument gets diluted. Why? Because that attorney had the ability to go ahead and bring this witness in, and there was nothing preventing him from going ahead and serving the doctor with this document called a subpoena, which would have compelled him to come in, give his testimony, and now he would know exactly what he had to say. So raising that argument can be very dangerous for an attorney because he's now accusing one person of not bringing the doctor in. Hey, Oginski's hiding something? Well, guess what? You, the defense attorney, had the ability and the capability to go ahead and bring that doctor in, but you chose not to as well. So don't point a finger at us, counselor. Can I make the same argument later on? Yes, I can. But then the defense attorney can raise the same argument I just told you about in his defense. So why do I share this quick information with you? I share it with you just to give you a sense of what goes on in these medical malpractice trials here in New York. You know, I realize you're likely watching this video because you wanted to see the scenery on this beautiful day today. No, I realize you're watching this because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.